A second major problem facing the news industry is the devaluation of editorial content. Editorial content is free and abundant, or at least that's the expectation. Many people get news through headlines and lead paragraphs on Google News and other aggregators such as Newser and Huffington Post. Google says it sends many readers on to the news organization's own websites, estimating that 35 to 40% of traffic to major U.S. news sites comes through a search engine. But the news organizations contend that Google News undermines their own efforts to attract readers. Although Google News uses headlines and lead paragraphs copied verbatim from various online news sites, this practice generally has been considered, in the United States at least, permissible under copyright law for two reasons. First, the idea-expression dichotomy of copyright law means that facts and ideas cannot be protected or owned under copyright, whereas expression can. News is primarily factual and thus receives only thin copyright protection. Second, the doctrine of fair use allows anyone to exercise certain exclusive rights of the copyright owner in some cases, and Google News maintains that it engages in fair use of the copyright-protected news stories. But as we speak today, Google News faces claims of copyright infringement by U.S. news organizations, as well as unfair competition and antitrust claims by European newspaper publishers. Broadcast news is not immune from some of the same forces that have affected newspapers. Broadcast viewership is fragmented and revenues are down. Like newspapers, broadcast news organizations have laid off hundreds of journalists. YouTube's efforts to compile local news video have led some broadcast journalists to wonder if YouTube is the same kind of frenemy to broadcast journalism that Google is to newspapers. Well, for those of us who care about journalism, this situation is alarming. I believe the function of journalism, an independent examination of the events and issues of the day, is as important and desirable as ever. But the news industry's traditional monopoly over publication of news and information is gone. News industry leaders now face the reality of re-envisioning and reconstructing the economic model of news. Even though independent journalism is critical in a democratic society, there is no guarantee journalism as we've known it will survive changes in technology. But I certainly hope it will, and I have some reason to be optimistic. However, to survive and to thrive, journalism organizations must be smart about, among other things, copyright law issues. I think journalism could learn a few things from the mistakes of other industries such as music and entertainment. Right now, news organizations are heading down a path of rhetoric and copyright infringement litigation that might not be the best approach. Increasingly, the news industry is turning to its copyright lawyers for reprieve and hope for the future. Associated Press CEO Tom Curley, News Corp chief Rupert Murdoch, and media news boss Dean Singleton, whose now bankrupt company owns the Salt Lake Tribune, among other properties, are among the news industry leaders who literally say they are mad as hell about copyright infringement of online news content and they are not going to take it anymore. But if copyright law is to remain the engine of free expression, as Justice Sandra Day O'Connor once called it, then some recognition must be made, including by journalists, that journalism engages in fair use of others' copyright-protected material in producing news. Thus, journalism may not, on balance, benefit from a copyright regime that too strictly regulates use of creative expression, including news. 30 years ago, in his remarkable book, The Gift, the author Lewis Hyde defined the modern American free market as one in which the people are free, but the ideas are locked up. The critical question facing journalism today is this: can the free trade in ideas at the information gathering or news gathering stage coexist with what is increasingly a restrictive commodification of ideas at the corporate publication and post-publication stages? Well, in just the few minutes that I have this morning, I hope to address this question by trying to accomplish three things. First, to discuss the history of copyright law protection for news. Understanding that history may give us some clues about the way forward. Second, to share several contemporary examples of the challenges faced by online news organizations. And finally, to propose a few ideas about what the news industry should and should not do as it seeks copyright law solutions to its business model problems. Recently, I've had some correspondence with a British scholar named Ronan Deasley, who has argued in an excellent book that the rise of newspapers in the late 17th century contributed to the government's recognition that printing could no longer be controlled through licensing and direct censorship. Instead, the government maintained indirect control over publication through the stationer's company monopoly over copyright. In other words, Deasley says, and also other scholars say, the origins of copyright law grow out of censorship interests. The first copyright statute, the Statute of Anne, came into being exactly 300 years ago. Its stated purpose was not to allow censorship, but rather to encourage learning. The Statute of Anne sought to provide an incentive for the production of socially beneficial expression. The sweat of the brow rationale associated with John Locke was not at the core of copyright law's economic reward. Although the Lockean notion of receiving the fruit of one's labors is at the heart of continental European laws that grant authors rights of paternity, which is the right to be named as the author or creator of a work, and also integrity, which is to prevent derogatory uses of one's work. The Statute of Anne made no mention of copyright protection for news or newspapers and was in fact specifically focused on books and the book publishing industry. The discussions leading up to the Statute of Anne focused on booksellers and publishers rather than journalists, although this is really not too surprising considering that newspapers in Britain were only in infancy stages at the time of the adoption of the Statute of Anne. Built on Enlightenment ideals, the Statute of Anne reflects the tenet that the truth belongs to no man. Like the Statute of Anne, the first U.S. Copyright Act, adopted by Congress in 1790, was focused on providing an incentive for writers, artists, and other creators, and not on enriching corporations. In the United States, the Copyright Clause in the U.S. Constitution refers to authors, but does not clarify whether journalists are included in that term. Indications are the framers of the U.S. Constitution and early U.S. legislators did not consider news to be a subject of copyright protection. The Copyright Act of 1790 explicitly protected books, maps, and charts, but not news. An early federal circuit court case in the early 20th century demonstrates the lack of consideration for news in the U.S. copyright scheme. The Western Union Telegraph Company transmitted and received news items through a ticker. The ticker printouts were made available in restaurants, hotels, and other public gathering places for the public to read. A rival National Telegraph News Company employed representatives to read the Western Union ticker tapes and then transmit the same information over the National Telegraph News wires and tickers. Western Union sued for copyright infringement, but the U.S. Court of Appeals for the Seventh Circuit in 1902 concluded that the ticker printouts were not the type of literature contemplated for protection under the Copyright Act as it then existed. Thus, for the Seventh Circuit, the sine qua non of copyrightability was originality, or, to quote the court, something meritorious from the author's own mind. Reporting of news, meanwhile, at least in the view of this court, required no originality on the part of the writer, who produced a mere annal by recording events in much the same way anyone else would have recorded them. In the 1909 revision of the Copyright Act, however, Congress explicitly provided for news as a subject of copyright protection. Thus, in a lawsuit brought by the Associated Press against another news service accused of appropriating AP news stories for unauthorized distribution, the U.S. Supreme Court said news articles could possess a literary quality and could be the subject of copyright protection. This was so even though the court acknowledged that no one could own the facts at the heart of a news story. The court got a little bit creative in this case in 1918 and used a branch of unfair competition law to create the doctrine called the hot news doctrine.